In North Carolina, I've had my legislator change so much in recent years that shortly after Trump took office, I wanted to call my rep to complain about tell him not to vote for some bill or something. And I call, his DC office, and the assistant that I speak to, I tell him where I live, and he tells me that oh no, you have this other congressman who you should be calling. And I said, no, I was in his district before, but now I'm in your district. And it was too much for him to comprehend that they hadn't updated their maps yet. So I was incapable of petitioning my representative not to support a bill.
This is kind of the interesting part about living in a post-fact world, right? Where sort of, these are highly factual determinations that need to be made, but facts are completely out the window. Yeah, you live in that guy's district, not mine.
As far as I'm concerned, this call is harassment, and if you petition your representative again, we'll have you arrested. That's Tom. It wasn't that Tom Cotton. Tom Cotton sent a cease and desist to everyone in America not to complain to him about the law.
This is amazing.
He was trespassing the entire country from his office.
We have taken the Constitution in an in rem proceeding, and you can't have it back.
I don't fuck with you. You little stupid ass bitch, I ain't fucking with you. You little dumb ass bitch, I ain't fucking with you. I got a million trillion things I'd rather fucking do than to be fucking with you. Little stupid ass, I don't give a fuck.
Hello, everyone, and welcome to episode 5 of Mike Dicta, America's best-named legal podcast. I'm your host, Charles Starr. We've got a couple of our regulars back, and we've got a new member of the panel today. Let me introduce everyone we've got here. First up is the Hell Dude, Tarik.
Hello.
With us again, first appearance, I think, since the first episode. Everyone say hi to Michael.
Hello.
And with us for the first time from North Carolina, a capital appellate defender, which is good for today's topic. Everyone say hi to Twitter's Kept Simple, known today as Mark.
Hey, everyone.
That might be surprising to everyone who knows him as Kev, but everyone who knows him as Kev knows he's not Kev.
I think that was true at one point, but it's not true anymore. I think many people actually think my name is Kevin. The joke has expanded beyond what was originally a joke.
Wait, it's not Kevin?
We have.
So it's Kevin because in 2013 or 14, I got an email from someone in the Attorney General's office here who's my opposing counsel in a case that was coming up for oral argument very soon. And I was very stressed out about the case. And she we'd been having a back and forth for a while, and she just addresses me as Kevin in the email. And I made the mistake of tweeting about that and complaining that she got my name wrong. And I thought maybe this was some sort of mind game she was trying to play with me. And the obvious result of that was that everyone then just started calling me Kevin on Twitter too.
You're the Kev dude.
That's right.
That, interestingly enough, is how Mark ended up on death row and interested in capital appeal. So we are actually going to do a bunch on the death penalty because there are a bunch of interesting cases kicking around. The first one I think we're going to talk about is Hidalgo v. Arizona, which is an interesting case for two reasons. First, because the sort of very specific challenge to the Arizona statute is right now there is a cert petition pending in the Supreme Court, and they've relisted it a couple of times, but they haven't decided to grant or deny yet. But the more specific complaint to Arizona is that Arizona has a capital scheme, and someone can step in if I get this wrong, but they have a capital scheme with aggravating factors that change first-degree murder to death-eligible first-degree murder. And there are so many aggravating factors that 99% of the first-degree murders committed in Arizona in the last 10 years or so are also death-eligible. So it really does not limit the difference between first-degree murder and death and capital eligible at all.
Right.
And then
Sorry, go ahead.
And then the second, and we'll get to this a little later, is beyond just attacking Arizona's scheme for determining whether a defendant is eligible for the death penalty, they have a full-on attack on the constitutionality of the death penalty in toto, basically because of the discriminatory enforcement and the impossibility of creating a scheme that avoids that discriminatory enforcement. I think I find it hard to believe that this Supreme Court is going to grant on the second question at all. But I think the first is interesting. I mean, both are interesting questions, but I just find it unlikely that they're going to accept a challenge on the constitutionality of the death penalty in general. Thoughts?
I mean, I would say that, even on that first question, though, I mean, the court, I'm sure, knows this, is if they were to invalidate Arizona's death penalty or accept this challenge in any way, that it would really basically be the end of the death penalty as we know it in the United States completely, because the system that Arizona uses is the system that basically every state in the country uses. Some states do it a little differently. Texas does it a little differently, but the aggravating factor system is how the death penalty has been implemented in the United States since the 1970s.
I mean, that's interesting. I mean, the Hidalgo petition certainly doesn't phrase it that way, right? They make a point of distinguishing Arizona from other states in that other states have like fewer aggravating factors and a lower percentage of first degree murder offenses are also automatically capital eligible. So at the very least, they may be trying to define the outer bounds of what an aggravation scheme can look like.
Yeah, I mean, I think they're certainly trying to do that, and certainly Arizona's. I looked at them, and it seemed like the first half were these sort of traditional aggravators that almost every state has, and some
actually, you know what, Mark, let's just take a second.
Yeah,
do you want to
please.
just sort of talk people? Do you want to talk people through how an aggravation, how states using this kind of system will distinguish between first degree murder and capital murder?
Sure. So, like, the way we wound up this way was in 1972. There was this Supreme Court decision, Furman v. Georgia, that basically invalidated the death penalty as we knew it in the United States. It ended it for about a 4-year period. And before that time, basically, what you saw in a lot of states was it was just completely open, who got the death penalty, who didn't. It was an open question for juries. There was no guidance whatsoever provided to them. And the Supreme Court said at that time, you can't do it this way anymore. It's too arbitrary, and two, it doesn't really narrow who is death penalty eligible to, what are sometimes called the worst of the worst offenders. Every murder is certainly bad, but the death penalty is supposed to be for these very few really bad murders. And so when the Supreme Court allowed the death penalty to come back in 1976, in this case, and another Georgia case, Gregg v. Georgia, they endorsed this system that had been basically invented by the American Law Institute, which is sort of exactly what it sounds like. It's just these like law professors, sitting around in a room and deciding what the law should be, not done with any like empirical data or anything. And they came up with this aggravating factor system where, basically in order to be eligible for the death penalty, first the person has to be guilty of what's often called like first degree murder, which is usually either an intentional murder or premeditated murder, or felony murder, which is when you kill someone in the act of committing some other dangerous felony. And then in addition to that, you need to have one of these statutorily enumerated aggravating factors that are set out in a statute, and a jury needs to find at least one of those exists before the person can be sentenced to death. That usually, sorry, go ahead.
So is the aggravating factor something that's charged and needs to be proven, or is it just enough to allege that it was there?
It needs to be proven to the jury beyond a reasonable doubt.
Is that usually at the sentencing? I think usually the aggravating factors are done at the sentencing phase, not at the guilt phase.
In most states, it's done at the sentencing phase. In Texas and a handful of other cases, it's done in the guilt phase. But I mean, the effect is the same. It just depends on whether you do it in one part of the trial. The part of the sort of death penalty trials have two parts. There's sort of the usual part that you think of in any criminal trial where the jury decides, is this person guilty or innocent of the crime? And then if they say, yes, you are guilty of first degree murder, then the jury goes on. If it was charged capitally, it goes on to this second phase where the jury then they'll consider the aggravating factors, and they consider what are called mitigating factors, which is, exactly the opposite. Any fact that the jury might find that would make the person, less deserving of the death penalty, and then they weigh those and decide what sentence to impose.
Michael?
Oh, I was just saying the classic, aggravating factor, I think, in practice is being black. And the classic mitigating factor is being white. Well, right?
It's funny you should mention
that. They found, I think, specifically in Greg that was not justiciable.
But Arizona, I think, has actually found a nice little workaround on that, because one of the aggravating factors is that the crime was committed in the furtherance of a street gang. So,
there you go.
No, specifically a street gang. It's, not one of those down home Italian, white gangs.
Right, and so the usually, I think what I remember in Arizona, they had the factors were particularly heinous. Mm-hmm. I think. Or it was in the course of multiple murders was an aggravating factor. If it was mitigating factors are usually the sorts of things like abused as a child or mental deficiency, whether, borderline IQ and things like that are all the kinds of things that they use as mitigating factors. Right. Though I don't know that mitigating is usually enumerated in the same way that.
And if you care, I can. So the Supreme Court has said that the jurors have to have the ability to consider literally anything as mitigating, basically. So you can. It's a matter more of strategy what you decide to put up. But aggravating is.
So he had it. So he had it coming as a mitigating factor.
So if you, I'm not going to go down that road, but it is. If somebody say it is very broad. But the aggravators you're talking about, the ones in Arizona that you specifically mentioned, those are all those American Law Institute aggravating factors that I think basically every state has, and they are the ones that are, the petition makes a big deal out of the raw number of them, but it's often just that it's a single aggravator can be incredibly broad in and of itself. So if you had a prior serious offense conviction, if the murder was committed for pecuniary gain is another one. And I think when people hear that, they think, oh, it's like a hitman or something. But that means in most states, if you kill someone and as an afterthought grab their wallet, that's pecuniary gain. And that separates that murder from, Jesus. A non-capital murder. The especially heinous, atrocious, and cruel is another one. I mean, it's basically a catch-all and can be obviously hard for a jury to determine whether, this murder that they've spent weeks hearing about is more heinous than a typical one.
As a defense attorney, what do you do? Do you stand up there and talk about other murders that are just so much worse?
Well,
so this one is comparatively
I'm not a trial attorney because I'm a coward. But certainly in appellate proceedings, you do
You're
talk
the hindsight
about
attorney.
you do talk about cases that have, if you're talking about you do cite cases that have resulted in life sentences that were truly awful, and that is something that you see, and it just further demonstrates just how arbitrary it is that you will see cases where someone has killed 5 people or committed a rape and murder in a horrible way that have gotten life in front of a jury, and then there are other cases you see where someone basically freaked out during a drug deal and shot someone and killed them and got the death penalty because of that. And it often, has less to do with the facts of the offense, and it has more to do with, how good their attorney was, the jurisdiction, and not just the state. And I think, this goes to how arbitrary it is. It's really the county you're in. There's really just a handful of counties in the whole country make up a huge percentage of the number of death sentences, like Harris County, St. Louis County.
I mean, well, that's interestingly enough, that's also part of the Hidalgo brief, where I think they basically say that you're essentially death eligible if you do it in Maricopa County,
right?
Because there are a lot of counties in Arizona that literally don't have the budget to deal with capital trials, and so they just don't charge the death penalty at all, whereas Maricopa County is just death crazy, and they charge basically anyone who's coming in for first-degree murder with a capital crime.
Right. They had a few years ago, they had some insane number of pending capital trials in Maricopa County that was actually they couldn't find enough defense attorneys in the whole state or something to appoint to all the cases, just because, like you said, every case was being charged capitally. And, you'll see that.
And every time they crossed the county line, Arpaio arrested them.
Right. And I remember around that time I spoke to a trial lawyer who practiced in Maricopa County, and he said that he was representing an undocumented immigrant who was charged with capital murder, and he had experience with that in a prior case, and in jury selection, there were jurors who would say basically they didn't care about anything else. If the person was undocumented, that was enough for them to think the person should get the death penalty.
That really strikes me as an unconstitutional aggravating factor.
Right, certainly.
I mean, I don't do that. It's not my area of practice. But if I had to guess. And so there we are. It's interesting. I'm still coming back. I'm surprised that this is essentially what it's like everywhere. Though it certainly, I think, has to feel that way if you're doing capital appellate work, because there really is a huge section where they try to show that Arizona is worse than any place else in the country. I think they distinguish it from Texas.
And I think, well, another thing I noticed in the Arizona brief was that Arizona is one of the states where felony murder is death penalty eligible. That's true, not true in every state. And I noticed in the brief there was a footnote that said that felony murder is death eligible, and one of the eligible felonies was transporting marijuana for sale.
Jesus
so
Christ.
if you're driving a car full of weed and you run over grandma by mistake or something, that's you're suddenly eligible for the death penalty. It's true. I mean, I think they do a noble effort of trying to distinguish Arizona, but I don't really think it's that different. I mean, I think you're seeing more cases charged in Arizona because that's a death penalty hotbed now. But there was a study in Missouri a few years ago that I think reached that same 99% cases death eligible number. It was very close. It was high 90s. And again, I mean, these, you see in all these states did the same thing. They adopted these American Law Institute aggravators. And then, every few years, state legislatures are, of course, filled with idiots. So they, hear about some bad crime, or they hear about something in the news is a new, type of crime that's sweeping the nations. They add that to the aggravators. So that's how you see like stuff like street gang in there and things like
The
that.
knockout game.
Right. Yeah, right.
Right.
Should get that on there.
Well, that was like the in the sort of the reply brief, the state basically said, well, this isn't even proper because, the case at hand, when you were sentenced, there were only 10 aggravating factors, and now they're 14, and you're challenging the 14, but you weren't sentenced under the 14 factors. But they were like, well, when there was 10, it was 98%.
Right, yeah.
And now it's 99%. But it kind of goes to show how sort of ridiculous it is.
Right. Yeah. I mean, so one of the aggravators I saw that I'm sure is one of the newer ones is a murder committed using a stun gun in Arizona, which is an incredibly stupid aggravator to have. Like, why is that murder worse than any others? But how often does that happen?
Well, let me just say, just like a shampoo bottle tells you not to be taken internally, that stun gun aggravator, if you checked the history in Arizona, there is someone who killed someone with a stun gun and did not get the death penalty, and they were like, "Well, that's crazy."
Right? Yeah.
And so they added the
is
stun
using
gun
an actual
aggravator.
gun an aggravator, or just a stun gun?
Just the stun gun. If you use the
That's
actual
amazing.
gun, you're at least safe in that regard.
Holy shit!
Though I gotta figure that's probably to just play devil's advocate, because I certainly think these people are in fact the devil.
Advocate away.
I wonder if it's just because in that particular case, it was just something where it was effectively torture.
It just kept
they
stunning
were
them,
they just kept zapping some dude, and for some reason they couldn't convince that particular jury that it fell under the heinous, atrocious, and cruel, and so they just wanted to sort of have a very specific aggravator.
Can we take a time out to mention the rat zapper again here?
Is that the
Mike
first
Dicta.
sponsor?
Let's cut that out.
Mike Dicta, brought to you by the Rat Zapper. We actually haven't checked in with Robin since to see if her infested apartment has gotten
Well,
any
if she got a
better.
rat zapper, I think I have one of those things, and it's excellent. It's
There you go.
It's a must in New York.
Thank you, Michael.
Yeah, but now, unfortunately, Mark is now representing the vermin in Robin's apartment against the Rat Zapper.
Well, no, I'm representing Robin because she's killing the
So I just wanted to, one more thing before we leave Hidalgo. I just wanted to point out, I mentioned that Maricopa County is Arpaio, but in this brief, I also saw that the long-standing county attorney in Maricopa County got disbarred because because of essentially bloodlust. Because they throw that in a footnote. They throw that in a footnote too, where they just mention how crazy Maricopa County is and how arbitrary administration is. Right? They mentioned that it was the jurisdiction of Arpaio that had, and then they also mention that Michael. Wait, who was the county attorney who was disbarred because, quote, he had outrageously exploited power, flagrantly fostered fear, and disgracefully misused the law.
Wow. You can get disbarred for that?
Indeed, some form of prosecutorial misconduct has been found in 21% of capital cases in Maricopa County. Like, it's not enough. It's not enough that everything that could possibly happen in the course of a crime is an aggravating factor. They also cheat.
Well, but to get disbarred is, that's something else, because I always was led to believe unless you steal from clients, you're fine. So to get disbarred from what you think would be normal prosecutorial behavior in Arizona, no less, that's impressive.
I mean, I'm sure that was his defense. It's a long-standing tradition to bend the rules exactly this badly in Arizona.
Right.
So the second case I want to talk about is currently pending, I guess, back in the 11th Circuit. It made a little bit of news because the case was called Tharp because the facts were so crazy, and then Thomas defended them. And so, oddly enough, I'm going to end up defending Thomas a little here.
Awesome.
But the basic facts of Tharp are that he was convicted of murder, and he was sentenced. I think he was sentenced to die. Another capital case, and 7 years after the conviction and the sentence, some representatives or attorneys of the defendant, Tharp, basically found one of the jurors hammered, just absolutely hammered at a bar. And he just started talking about really racist, like,
well, he was talking about,
he did the Chris Rock, N-word and colored people routine. He essentially admitted that if the victim had been a lowlife just like the murderer, he probably wouldn't have sentenced him to die.
Right. There are two types of black people.
Yeah, he did the colored,
right.
the black people and N-word distinction.
Right, and he knew the victims, and he knew them to be good people.
Knew them to be good people.
Yeah.
And so they were good, and he also questioned whether black people have souls and go to heaven. And then somehow whoever got him hammered wrote all of this down.
I don't think
and then had him sign it. What?
I don't think they got him hammered. I think he maybe just was hammered.
Well, I mean, I think no. I don't know. I'm not saying they fed him all the drinks, but I think there is definitely the whiff of the fact that they found out he was a racist and frequently drunk, and they got him to spill.
It's an interesting thing. Just to connect back to Hidalgo for a second. Do you have a soul is actually one of the aggravating factors. It's number 13.
It's actually in Georgia. At the end of the sentencing phase, the judge shows them that Chris Rock routine from the 90s on black people versus the N-word, and those are there, and that's in lieu of instructions, and that's how. So everything he did was completely within the law.
Right. Totally makes sense.
So he signs this. So he actually signs it, right? They write down all of the crazy racist stuff he says, and he signs it.
But I just want to say this is a thing. This is how it's done. I mean, you go and you talk to jurors. You try to talk to every juror, and people will sign affidavits on the spot, and that's I would say what was done here was standard practice.
Right, though this doesn't sound like an affidavit. It sounds like the back of a cocktail napkin. Because he signs it, and then a few days later, the state gets him to sign a much more formal statement where he disavows everything he said in the bar.
Wow.
And claims that the other one wasn't notarized, and he was really drunk at the time, and that race had absolutely nothing to do with anything. And so faced with these facts, the 11th Circuit had a credibility hearing. They had a big fact finding on everything. And the 11th Circuit basically said, this changes nothing. The jury is sacrosanct. The other 11 jurors all said that race didn't play a role, including I don't remember if it was one or two black people on the jury. They all said none of that mattered. And so the 11th Circuit let it slide, and the Supreme Court gets this, and they write like a 2-page memorandum opinion where they basically go, holy shit. And they just send it back to the 7th Circuit with like no findings. Right. They're just like, "Are you sure about this?"
Right. And they're not even sending it back on like the merits. They're sending it back for reconsideration on certificate of appealability, which is like the initial thing you need to get for them to even consider the appeal. So it's like telling them they need to reconsider whether they will consider this. It's very kind of narrow and really kind of wimped out.
That's like sub certiorari, or what is that?
So in habeas, because they find different ways to make habeas more difficult for you, when you're appealing from a district court's decision in a habeas case, you don't just file your appeal with the circuit court. You need to, you either ask the district court or you ask the circuit court for what's called a certificate of appealability, which is this sort of threshold issue of whether the question is even basically worth considering, or whether it's a question that someone might grant relief on. And he was denied that, and now the Supreme Court is saying maybe reconsider that.
Right. They don't even say you get a certificate of appealability. They basically are like, did you read all the racist things he said? Let's take a hard look at this. And so Thomas with Alito and was it Gorsuch?
It was Gorsuch
in an early.
Yeah.
So Thomas with Alito and Gorsuch dissents from the per curiam, because no one even put their name on the decision to send it back. But Thomas dissents with the other two, and he's like, that the district court actually read this, right? And so he goes through all of the reasons that the district court denied it. And I used to tell people all the time that there was a really quick way to tell whether the Supreme Court was going to grant a capital defendant a new trial or not. And the easy way to tell in the first couple of sentences is if they're going to grant the guy relief, it starts by talking about the importance of the appellate process.
Right.
And if they're not going to grant relief, it starts with a lurid description of the murder.
Right.
Right.
Absolutely.
If you are not going to grant the person relief, you make sure everyone knows how terrible it is. And so that's essentially what Thomas does, right? He basically is like, these are unusual facts. It's bad law. Now I'm going to tell you about how horribly he murdered his sister's friend and raped his wife's friend or his wife's sister. He went just. There was a lot. It's a terrible crime.
Well, he mentions the race and gender of the victim.
Yeah.
Right.
A black woman is seeking justice here, and the court is getting in the way of that, which is really just terrific.
Yeah. The victim is black too, by the way. I mean, is sort of not sort of thing, like actually what he pulled.
Literally, the last paragraph.
Yeah.
Yep. And so, but Thomas's response is basically like, he did sign this statement, and it's just as bad as you say it is, but everyone in that jury room said that it had nothing to do with the verdict. They found he was clearly guilty about all of these things, and this process is just so weird because the 11th Circuit is just going to deny the COA again, and we don't know why this wasn't just a run-of-the-mill thing. And the more you read through the facts, you end up being a little sympathetic to Thomas's point, where he's just like, there was a credibility determination. They read the affidavit. They read his later statements. They took testimony from everyone. And, you're usually not supposed to peek behind the curtain. And this is why. He's like, this just has ended up being this, really weird sideshow where we have this long process question when no one really has any doubts about any of this.
Well, I think he has. I thought Thomas had a point in that when he he hits the majority for, just granting this rinky-dink relief, like you said, which was just this remand to basically reconsider certificate of appealability. And, what the court really should be doing here is, I think it's a case like this shows why the death penalty is so unworkable, right? Because you've got, like we talked about in Hidalgo, the jury has this, sometimes it's called guided discretion, that this aggravating and mitigating factors, circumstances that they're supposed to be doing in the jury room. But the minute you peek back there, what you see is, hey, maybe they're talking about, a Chris Rock bit from the 1990s instead, and not really considering doing what they're supposed to be doing at all. And if we really start to peel that back, we're going to see that, this structure that we've built up really is not doing what it's supposed to be doing.
Right. And I think Thomas is an underrated writer for one thing. I think a lot of the plaudits Scalia used to get, maybe Thomas
save it for the pod.
Like, sort of nutcracker opinions. He actually has like the clarity of writing, and so he can be very persuasive. But I think he's coming from a strong point also because our habeas system is so fucked, which I'm sure Mark knows and feels strongly about. But habeas corpus for our lay listeners is what you call like a collateral attack. It's not a direct appeal to a decision. So this is something that started in state court. It went through the whole state court process all the way up to the state Supreme Court, I believe. And then afterwards, you're attacking it in federal court and saying, well, there was something constitutionally deficient in my trial that was missed. And the standards of review are really, really bad. It's like the Supreme Court has to ask whether a reasonable judge could find that another reasonable judge could have found that a reasonable jury could have, thought this was
right. So basically,
and even worse.
Sorry, go ahead.
Yeah, and even worse. And Bill Clinton's worst act was not the welfare reform, and it wasn't DOMA. It was EDPA, the Anti-Terrorism and Effective Death Penalty Act, which makes habeas review so hard because not only does it have to be constitutional error, but it has to be constitutional error that has previously been found by the Supreme Court.
Right.
It used to be that the district court on habeas could look at the trial record and say, this is clearly unconstitutional and we're going to, give this guy a new trial. And now that's not even enough.
Now you get a mulligan.
They can say, it's not even a mulligan because the Supreme Court grants, it has to come to the Supreme Court on direct appeal before they'll even consider it in a habeas context. So you have to get the similar enough facts ruled on in one of the few cases that the Supreme Court takes as to be determined unconstitutional before it's even eligible for habeas consideration.
And on top of that, the state court gets all this deference in habeas review that also makes it difficult. So basically, you could have cases where the federal court will know that the state court got it wrong, but because they weren't so clearly wrong, you still don't get relief. And really what you end up litigating in habeas is not, the facts of the case or the, injustices that happen. You're litigating procedure and making sure that, the claim was raised in the court below and this and that. And it overtakes the case and the procedure swallows, the relevant facts. And I think that's sort of what you see here. And in this case, especially, you're talking about how habeas is a collateral attack. This was really a collateral attack of a collateral attack because it was a Rule 60B motion filed following the habeas, which is in the rules of civil procedure. It's a way to attack a verdict. So you're trying to undo a decision that the district court already had made in the case, so that becomes even another level more difficult. And the analysis becomes even further removed from the facts and more focused on whether, you filed the right thing at the right time and raised the right claim at the right time and this and that. And it's a nightmare.
It's funny that the people who, sort of at the dinner table worry that murderers are getting off on technicalities,
Right.
Are relying on technicalities to make sure that, actually innocent people or other folks don't get the light of day in court.
Right.
Yeah.
And you'll hear sometimes people say too, like, oh, these people who get the death penalty, they've had their case reviewed by 40 different judges. But really, once you've been through a couple of early stages in state court, everything that happened there gets so much deference in the later stages that you can't really fully count what a federal district court's review of what a state court judge did and whether that was reasonable is not really like a fresh set of eyes on the case.
Whether you correctly navigated the Kafka-esque labyrinth of habeas,
Right?
Yeah. I mean, it's funny. The more I read Thomas's Tharp opinion, the more I've decided that what it is a draft 11th Circuit opinion on remand, where he's just like, three votes for this, buddy.
Yeah.
Just cut and paste this, and you've got 3 votes to deny cert on, when Tharp appeals it again. Because he really does. He goes through, he's like, the main case that they're arguing isn't retroactive, so he can't even take advantage of it. He can't take advantage of looking behind the jury, you can't, he just goes through one thing after another just to say that none of it counts. Though I do think, one of the things that he says is that, it won't even help Tharp. And I'm like, well, I bet Tharp thinks it'll help him.
Anything will
it's
help
not
Tharp.
there is no scenario where Tharp gets to frolic in a field.
Yeah.
Right? They're like, Thomas is like, all this will do is postpone his execution. And all I could think when I'm reading this is like, well, that's, I think, kind of what they're going for.
Right.
Right? I mean, some of this is just, playing the clock, and so, he's not writing his own briefs. He's just trying to sort of have his attorneys keep him alive for longer. So that just seemed like gratuitously bitter on Thomas's part.
No.
Good old
Thomas. I have a tangent, but an aside about Thomas being bitter. I had a friend who clerked at the Supreme Court for another justice, and there is a tradition, I guess, where each individual justice will take out all the other justices' clerks to lunch once. And so at his lunch with Thomas, I guess unsurprisingly, politics came up, and somebody mentioned, I think it was Harry Reid, and Thomas made a face, and my friend, said that he thought that Thomas had been friends with Reid or something like that, and Thomas told him he'd show him something after lunch, and brought him back to his office, and in his desk, in his top drawer, he had the roll call for his confirmation vote to the Supreme Court with all the yays and all the nays. And he kept that shit for over a decade and had it right at hand. That is
Was Reid a yay or a nay?
Yeah. That's the kind he needs to get on Twitter if he has that kind of obsessiveness with his haters.
Yo, block that motherfucker.
2018, Thomas versus Reid. Yeah. Sue your haters.
We have kept simple on. So
copyright, Kev.
Yeah. Perfect.
So I guess we're going to move on a little from the low stakes. Oh, let's wait until everyone's got their files in order. 25 minutes of riffling. We're gonna move from the very low stakes of capital crimes to the very high stakes of gerrymandering, because that partisan gerrymandering is, shaping up to be one of the really big issues for the coming Supreme Court term. Right now, there are two and possibly a third case coming up. I mean, first, Gill v. Whitford, the Wisconsin case, is already in front of the Supreme Court. I think they already had oral argument.
Yeah.
They just granted cert in Benesek case out of Maryland. And the Pennsylvania Supreme Court just invalidated their congressional map. And so that is now... I think they actually invalidated the state map in Pennsylvania. The Pennsylvania Supreme Court invalidated the Pennsylvania map. And so that's coming. That is, I think they've asked for an emergency stay, though I don't think that's been ruled on yet.
No, they just
a lot going on.
Yeah.
Say again?
They just put in the stay. It hasn't been ruled on yet.
Right.
But there's also then, I think the North Carolina case might also end up at the Supreme Court.
Yep.
Yep. Yeah, there's a lot.
Yeah, and a lot of stuff, going on. That's Rucho, I guess, is the North Carolina case. Yeah, so a lot of stuff going on, and the big question is whether these states have gone too far in partisan gerrymandering, right? When one party gets control of both the executive and the legislative, whether they do too aggressive redrawing of maps. And I know the Wisconsin case, I discussed this one for a while on This Week in Atrocity with Jeb Lund, but the case in Wisconsin was based on a theory called the efficiency gap, where a fair map is so where the map as drawn is so far away from what a fair map would look like based on the actual voter preferences in the state, there's a threshold at which it becomes unconstitutional. And one of the example they gave in Wisconsin, and it's been a while, so I don't remember the numbers anymore, but I think there are 99 seats in the Wisconsin assembly, and the vote was pretty close to 50-50.
Democrats got 52%. And they got...
And the Republicans ended up with a super majority.
52% of the vote and 39 out of 99 seats, which is
right. So 60 to 39 Republican advantage in representatives, even though they actually had a minority of the vote. And then, of course, in the next election, as Walker got stronger in Wisconsin, I don't know how it would be today, the Republicans actually did get a majority of the votes, right. And then I think they increased their majority in the House to something like 65 or 66 seats, right. And they actually ended up with like a 2/3 supermajority, which I think allowed them to literally imprison anyone who voted against a bill introduced by a Republican.
Right. They use these majorities. I mean, you're joking, but they did use those majorities to pass voter ID and right to work, which both really punish Democrats at the ballot box in other ways, hurt their organizing and hurt their get out the vote efforts. And
I'm sure Mark knows this because it's even like North Carolina is like ground zero for incredibly vindictive legislative chicanery. I mean, one of the last things McCrory did, right? I mean, you'll remember this. As McCrory left office, he essentially signed away all of the powers of the governor to the legislature. because they had a supermajority in the legislature.
Right, and they did this thing where they've tried to move the election board into this ethics board so that the new Democratic governor doesn't have as much control over it. And it seems like they've tried to do basically any and everything that they can think of to, make it easier for Republicans to get elected, to make it harder for, minorities and poor people to vote. And some of those things have been invalidated, but not all of them, certainly.
Right. Right. I thought one of the interesting things about Venasek is, almost all of these cases have taken the stance where, as Republicans have taken over state houses across the country, it's usually them who are doing all of the dirty work of disenfranchising Democrats. And Venasek is interesting to me for two reasons. First of all, because it was a Democratic governor and legislature which redrew this one district.
Right.
And what's interesting about it is they only challenged, it was a Republican who was in a very safe Republican seat, who had his district redrawn by, oh God, why can't I remember his name? It's the presidential candidate who got like one vote. The governor of Maryland.
O'Malley.
Martin O'Malley.
The sexiest of all the presidential candidates.
O'Malley would have won.
Martin O'Malley.
So O'Malley was one of the guys who passed this. He redrew this one district, and so this Republican who went from having an incredibly safe seat in the new district he had to run in got blown out. Right? He went from being plus 20 to minus 20. And so he basically argued that he was the victim of a partisan gerrymander, though it was only his district as opposed to statewide in North Carolina and Pennsylvania.
Right. And there's also different, I think, constitutional issues at play, right? Like Wisconsin, I think it's based on equal protection in the voters saying they're not getting equal protection of the law, whereas I think in Maryland the primary argument is based around the First Amendment and political association and being punished for your political
Yeah, though I think to me what's interesting about it is Venasek, like the Venasek argument is probably giving the Wisconsin and Pennsylvania legislatures seizures, because the Venasek argument is that partisan gerrymandering is essentially improper in all cases, right? I mean, this guy is trying to protect his own district, and he's firing away at a Democratic government, a Democrat-run government, but he is using arguments that would cripple the defenses in the Gill case and the North Carolina case and the Pennsylvania case. And so it's just a really funny situation where the one Republican victim of all of this is trying to blow the whole thing up because he's mad because he lost his seat. Yeah. And I'm just surprised he hasn't been like handcuffed and thrown in a closet before he could file this thing, much less get it in front of the Supreme Court. And I just figure that Alito is going to figure out a way to thread the needle where every Republican gerrymander is fine, but this is the one improper one. Right. And this guy gets his seat back.
That's actually, if there's anybody who could do it, it would be Alito, the quintessential partisan hack. But
yeah, I mean, it's just a very funny, and to me, like when you read the response, right, asking to affirm it, they're like, well, usually the problem with political gerrymandering is that it bakes in permanent change. And the guy who ran as a Republican after this guy got kicked out of office damn near won.
Right.
even though he was outspent like 5-1, and the underlying voting isn't nearly as bad as he's claiming it is. And also we kept counties intact. And the problem, the guy is complaining about having his district redrawn, even though his district was drawn as a horrible partisan gerrymander in the first place. Right. Like they incorporated 2 counties by having the district go across a bridge and like take in like some really big white suburb, which gave all of the votes to this guy. And so they're like, we redrew this along all of the good nonpartisan principles, and you're just mad because you lost. So, back to suing your haters.
Yeah, exactly. This is suing your haters. I think that belongs in the canon. He started early on this, so he got the ground rolling.
He's a pioneer in suing your haters. Because I think he sued, I guess he started suing back in 2011 and just keeps, like, he just kept losing. Sounds a lot like his election, honestly. But he did get cert, so, like, there's nothing great about it.
Well, I mean, I think that the Supreme Court has to take these cases in almost all circumstances. It's kind of quirky, which is one of the reasons why I think a few of the justices, literally, I think Alito said, or Roberts said at oral argument that, one of the reasons to sort of just say the Supreme Court shouldn't have anything to do with partisan gerrymandering is because once they say it's a constitutional standard, every single map will be challenged. The Constitution of the United States says that you challenge those in front of 3-judge district panels, and those get directly appealed to the Supreme Court, and the Supreme Court has to take the appeal, like in almost all cases, and that the Supreme Court will just be hearing gerrymandering cases all the time, and they don't want to do that. And
which is, I mean, that's very Roberts,
of course,
is to like throw things out because it means having to do his job.
Exactly. Right.
Like I think half of Robert's opinions are like, this is just more work for me. Dismissed.
It's remarkable, this like strain through his and a few and conservative, jurisprudence in general, where it's like a real disdain for things being decided in courts. It's like, more stuff for the courts to do. It's like,
why can't you just agree on the side?
Well, it's like half the time the Supreme Court printer has to like reissue opinions where they delete Robert's tea time.
Well, I mean, it's the same thing with habeas, right? I mean, they're just the whole thing is designed to prevent you from having your case actually considered in any meaningful way.
Right. Exactly.
Yep.
Yeah.
And so, and those are just the most frustrating, where they give short shrift to the facts, and then they're like, I didn't really read all of this, but that's okay because my ruling is that I shouldn't have to have read any.
Well, that is the second layer of it, where they're like, oh, we have to hear all these, and then it's always all this social science and all this statistics, and it's like, oh, that's so much. It's like, oh,
I think there actually was an exchange during the court where Roberts did say something like that, where he all of a sudden was unfrozen caveman lawyer, where he's like, all of these studies are so confusing. I'm just a simple attorney and I can't understand all this science. And then one of the other justices was like, we read these sorts of things all the time. Right. It's literally what we do. Right. Well, it's like, why are you doing this?
It's bizarre. It's not any different than the type of evidence they take in, racial gerrymandering cases, which they take, all the time, and they read social science and academics. It's not really that different at all. But I
mean, Scalia had a similar argument in there was a patent case, And he's just like, we all just pretend to know the science. Like, we don't know. Like, it's all gibberish. Who the fuck are we kidding? This is all, none of us understand any of this. And it almost, like, it was like a section of his opinion that could have been like insane clown posse. It's like magnets. How do they work? I don't even know why this is in front of me.
Truthfully, though, I don't know how.
Never since creation in 7 days has a judge had to decide a case involving science.
Well, and, one of the complaints is the idea that this will make, the Constitution, put social science into the Constitution as a constitutional standard, which is garbage. But what I really liked about the North Carolina opinion, I don't know if anybody else read it. It is a 200-page behemoth.
That's a no.
I assume not. But I read it, and I think what the court did that was really nice is they made a point of saying basically the social science isn't the standard. The standard is there partisan intent, and is there a partisan effect? And can that effect be described by something else that's like a legitimate concern, like geography or communities of interest, things like that. And the social science is evidence, which judges hear all the time, and they hear, experts weigh in on highly technical things as evidence, right? And that's it's amazing that it's taken somebody, 15 years to spell this out in a clear way that will like answer this inane critique that you hear. But
and the intent question is interesting, especially in Wisconsin, because of a persistent through line in Republican attempts to sort of steal the election nationwide in this sort of way. And it's the problem that Jeb and I always refer to as quiet part loud.
Right.
Which is that they constantly sort of show their ass. Like anytime you put a microphone in front of the right state representative, he just admits to the partisan intent of it and says something like, soon we won't, like, they'll never be able to elect a Democrat in this state again. We're going to draw this map so good.
Soon my enemies will be driven before me.
And one of the things that happened in Wisconsin was the Wisconsin tried everything they could to hide all of the deliberations from discovery. They outsourced it. They did it in a room where the Democrats had no access to anything. They hired outside experts who they believed to be essentially beyond the subpoena power, and they denied discovery constantly. And then when the judge finally made them turn everything over, there were just all these emails where they were like, can we make this map more partisan?
Well, that's like in North Carolina, there's like a bipartisan committee, but since Republicans had a majority in the state legislature, they had a majority on the committee. But so there's this argument that's sort of rehashed in the statement of facts in the North Carolina opinion, where it's like these Democrats are like, this map is just going to make it a permanent 10 Republican, 3 Democrat state, even though, it's very competitive and we're really concerned about that. And the Republican replies, he's just like, the intent is to make it to a 10-3 map because I'm not convinced we could make it an 11-2 map. That's like right there. He's just like, fuck you guys. It's unbelievably
it's like,
bold.
Like the 2 Democrats on the committee had to share like one office, which was a bathroom stall.
Right, exactly.
It's just one bathroom stall with 2 nameplates on it. So I think the upshot, though, is that this is going to end up before the Supreme Court, and they are once again like they're just going to. If it's voted on in like as partisan a way as all of these maps are drawn, they're basically just going to say, they're just going to be like, yeah, we can't hear this at all. Right. Though there is a Supreme Court case. There is a Supreme Court case called Veith, where they said there is I think it was Kennedy who wrote, like, it is justiciable, right? Partisan gerrymandering is a case that is theoretically possible. And then they refused to, like, decide where the event horizon was. Right. Like, just how partisan it had to be. And the Wisconsin case is interesting because they were the first judges to say, this is it. Like, here is a statistically valid measure that shows you where the horizon is. And this is so far beyond it. Right. You should really look at this and undo it. And I think one of the timing on all of this ends up being really crazy, especially with things like the House of Representatives, where the elections are every 2 years. The cases always take more than an election cycle. So you vote on a bad map, and then someone sues, but they don't get an injunction. And so another election takes place under a bad map, and then they replace it with another bad map. And so now you have to sue for that map. Right. And like, because none of this gets fast tracked, it ends up not mattering. Right. Because they just keep passing new unconstitutional maps that the elections can't catch up to. Because, like, they just don't matter for statewide office.
Yeah. So one thing I'll say about the Pennsylvania case that's encouraging, is that it was decided on the Pennsylvania Constitution, not the federal Constitution, which makes it very difficult for the Supreme Court to review. Not necessarily impossible, but very, very difficult. So for all our talk of Alito being a hack and Roberts being lazy and all that, and Kennedy being fickle, this does present perhaps the other avenue to take, if the Supreme Court is unavailing, which is most, if not all, of the state constitutions have a more robust protection for the right to vote. The federal constitution doesn't even actually protect the right to vote, which is something that when you think about is pretty fucked up, but is true. But almost every state constitution does, explicitly or sort of, in a roundabout way. So that might be the avenue to take in the future. Not
surprisingly, the people seeking the injunction cited a bunch of cases where the Supreme Court held that a state court, ruling on, what it claims were state grounds, but under a rubric that is the same as the parallel federal ground, were effectively deciding under federal grounds and reversed them anyway. Though, I mean, in those cases, you figure they would just remand and then, maybe theoretically, and have a new state principle, but that's sort of just where it's sat. And so, but I like to have hope about these things, but I end up being very kind of sanguine about like how much I think that this Supreme Court is going to change any of these rules while they, are advantageous to them. And so, like, they're gonna thread the needle on Gill and Banasek, and I'm gonna my head is gonna explode.
Well, I think most people
when they decide
when they accepted cert, when they decided to hear Banasek, it surprised a lot of people because it pretty much fast tracked Gill v. Whitford, the first case they heard. When that came up to them, they had already accepted, granted certiorari and decided to hear cases and scheduled them for, December, January, February oral argument. And then they accepted Gill and scheduled it for October. So it was like they were like, we're going to hear this quick. We're going to hear this right at the beginning of the term. It seemed like there was a lot of energy to decide it. And then they had oral argument. And everybody figured, okay, it's been decided, and now everything else they'll just stay until that opinion comes out, and then remand to all the other cases and be like, redo this in light of Gill v. Whitford. But instead, they accepted argument on Banasek, and everybody's like, wait, what? Like, we're doing more gerrymandering cases, and it's not even like argument hasn't been scheduled yet, so we don't even know when we're doing it. So now it seems like they're just going in on it, and it's hard to read the tea leaves on what that means.
I mean, that's certainly the hope. The hope for Pennsylvania is they're like, at least give us a stay until you decide Gill,
right?
Because, but that is, I mean, the tactic there is just the stay will almost certainly be long enough that a new map can't be drawn in time.
Right.
For the 2018 elections. And so that's really what they're hoping for with the stay.
The Republicans in Pennsylvania.
One more bite. Yeah, the Republicans are hoping for one more bite at the apple with this map, even if it is ultimately determined to be unconstitutional.
Right.
So our last topic of the day is certainly the most important of the three that we're going to address, and it is Milo's suit against Simon and Schuster.
The fans have demanded we address this.
Yeah, we have to talk about Milo suing his haters. In this particular case, it's Simon and Schuster who dropped his book. Just on the grounds that it was, in their words, unpublishable shit. Yeah. And so they threw the book out and they gave it back to him.
And he published it.
His advance, right? It was like 80 grand or something.
No, yeah. So
well, they let him. Yes, they let him keep his advance, which was 80 grand. But then he sued for like the remaining like $500,000.
Well, so the contract for this book is a standard book contract, which sets out the basic principle that we don't have to publish it if we don't like it. But there are steps in between that say you must do X or Y if you want to reject it. At some point, Milo became so toxic to Simon and Schuster that they decided to send him an email saying, "We're not publishing it. Keep the 80,000 that we just gave you. We don't want anything to do with this."
This wasn't the sweet Milo that we started out with.
Yeah.
We thought you were just a racist.
Yeah.
But it has come to our attention that you are apparently a defender of pedophilia.
You have not sufficiently,
and that is a bridge too far.
Yeah, you have not sufficiently, denounced pedophilia. So please keep the $80,000. Go away, and we will never talk to you again. They reverted the control of the book to him. He self-published it and then sued them, basically saying that they had not met the conditions in the contract, saying that they must give him notice and a certain opportunity to cure and deliver a new transcript to them with the edits that they wanted to make, etc. And that's where we are today.
Yep. And I mean, the first thing Simon and Schuster tried is they went right off the bat. They tried to go for an accord and satisfaction defense, right? Like because they sent the letter and they're like, you can keep the deposit. You can keep the advance. You can keep the advance, and that will release all claims if you keep the advance. And Milo essentially did nothing, and he
kept it.
Didn't return the money, and so then and then he sued for the whole thing. And so Simon and Schuster responded, and they're like, well, you kept the money. And he sent you a letter releasing everything.
And you published.
And then you published the book. And so we win. It's over.
Right.
Which seems
Go
fair.
home.
That's I don't know. That sounds right.
But it turns out, like, and we'll get to why this matters in a minute, but Milo's attorneys were very good.
They were good, yeah.
Right? His attorneys at the time, Mr. Seelig and Fine, are very good copyright attorneys. And they just took apart the accord and satisfaction defense because they're like, number one, usually the way accord and satisfaction works is you're like, here's a check, and if you cash this check, all of you're accepting our agreement to terminate this relationship entirely. And in this case, you didn't give him a check, you sent him a letter. He had that check for months. Right. You got that check when he signed the original book contract. He didn't cash it now. He cashed it then. All he didn't do is write you a check.
Right.
Returning the money. And if you read your own contract, dummies, he's got 18 months to do that. Right. So it doesn't matter that he didn't give it back yet. And the reason he self-published his book is because your letter didn't make reverting the rights of the book contingent on the money anyway.
And he was supposed to mitigate his damages by publishing
and
elsewhere.
They're like, number one, right? And there are like two reasons. Number one, you just released the rights to the book. It was in a different paragraph from the part where you said keep the advance and terminate all relationships. They're like, so he could have done this anyway, but even if that weren't true, he has to mitigate damages. Do you know how much Milo sold of his book? This is the mitigation.
I want to know.
How much?
How much?
$3,000. $3,000, which is probably 100 copies of Milo's book. Maybe 200.
Undersold gorilla mindset.
That is, he has mitigated so far to the tune of $3,000.
Holy shit.
I think we could sell this episode.
And that's part of his...
I think we could sell this episode of Mike Dicta for more than that.
and that's his argument. He's like, I didn't have the weight of Simon and Schuster behind me. Also, I said some pedophile sympathetic things. One or both of those may be factors. But the reason it matters that he had good attorneys then is because he no longer does.
Well, that's fascinating. Like, so his lawyers moved to be relieved on the basis that he wanted to do things that they didn't want him to do. And then he later released a statement.
Have sex with children.
Yeah.
Yeah.
And then he later he sort of simultaneously released a statement saying that he asked them to be relieved because certain discovery in the case was issued as attorney's eyes only, and he wanted to be able to see that. Therefore, the fact that those attorneys were in the way would permit him to see the discovery. The interesting thing is the order of the judge, as far as I can tell, is that all the attorney's eyes only stuff, which was protected because it had nothing to do with him and had dealt with trade secrets, and he was a competitor with his new publishing arm, etc. So terms of contracts with other writers, etc. He still doesn't get to see it for the judge. It's still. Oh,
really? Yeah. Even as a pro se, he doesn't get any of that?
They continue to protect it and have put it off to conference, hoping that he will either A, not show up, because the judge said if he doesn't show up in March, they're going to dismiss it, or if he does show up with a lawyer, then they will issue that discovery to him. But he is still not allowed to see those 4 or 5 emails that Simon & Schuster was seeking to protect.
I would love to be a fly on the wall of Milo wearing like his Johnny Depp level of scarves, like trying to read through Simon & Schuster's business records. Like, just like being like, this is all so boring. Yeah. Why do I have to do this?
Well, apparently it shows what they paid to Pamela Geller or something, because I guess he published her later. So there's this concept that he is competing with them with his new venture, which has protected certain emails that discuss other authors and stuff from him looking at them.
Yeah, I mean, the fact is, like, confidentiality designations are pretty typical. Like, the plaintiff usually doesn't need to see most of the underlying business records, though attorney's eyes only is, you could tell, I think Simon & Schuster did things attorney's eyes only because they trusted Mr. Seelig and Fine, a reputable firm
and they don't.
that does, like, quality work, but they know that, like, anything that Milo gets his hands on is going to be on WikiLeaks.
Right.
And so, like, there's no way they're letting him near their business records personally.
Right.
And so he no longer has an attorney because there was a disagreement over whether Milo was too big a nuisance even for his own allies. And so they quit. And so now he's pro se until he realizes that he actually has to do real work. Or, Simon & Schuster's attorneys are Davis Wright Tremaine, who are also top-notch copyright counsel, who will literally carve him up, like, and smile as he bleeds if he actually tries to go pro se the rest of the way.
The interesting thing is he had a pretty good case against Simon & Schuster, which is they wanted to drop him immediately. And the contract sort of suggested that if your manuscript sucked, there would be some back and forth over a period of time. That's why he defeated Simon & Schuster's initial motion to dismiss over all these things, etc. But they took a very aggressive posture. They moved for summary judgment. Milo did. Immediately, and you only get one in New York State Court. And the idea was that they thought they were going to be very aggressive with them, but I have no idea how Milo's going to step in now and continue that litigation posture.
That's what's in March is a summary judgment conference.
Yeah.
And he's filed it pre-discovery.
Yes, you get
because
one.
He was doing it.
You can take it.
He was doing it straight on a textualism,
or you can take it before. Yeah, but they filed early. They were being very aggressive, but for some reason, again, his lawyers say a difference of opinion. He says, "I just wanted to see these documents." He doesn't get the documents, so who knows what's going on here.
Yeah. I mean, it would be funny if, like, and my guess is the well is sufficiently poisoned that he can't just, like, call up Mr. Seelig and Fine and be like, fine, I won't look at the documents. And like, they're just going to be like, new phone, who dis?
Yeah.
There's no way they want to take that call again. Yeah. Because those meetings had to be just unbearable.
Oh my God.
For his attorneys, where, like, he kept trying to, like, head fake them and then grab the documents and run into a locked room.
And it's only like 5 documents from what I can tell. It's just,
oh, really?
It's stuff where, as part of an email chain, he was mentioned, and then they went on to discuss somebody else and their contract. So it's this very limited, apparently like 5 to 10% of the overall discovery is subject to this protection as it is. And he seems to think that there's something, absolutely like smoking gun there. But in my experience, I don't think so.
Well, I thought maybe it's just insane vanity that he really wants to see how he compares to like what was that person getting?
Yeah, I'm pretty sure.
That's literally just dying to know if somebody else.
That was the only purpose of this lawsuit.
Can you imagine being the guy who signed this deal for Milo's book, right? For $500,000, you sign this guy. And then when he self-publishes the book, it sells like 200 copies. How bad is your judgment of the pulse of America, right? When you thought that you could, you're like, well, he seems famous.
Yeah.
And you just gave him $500,000. And now you're going to have to, you've given him 80. And I got it. If he doesn't win summary judgment, this has got to settle, because it can't possibly be worth it to fight all the way to the end. And this is just.
How would it settle down, though, with him representing himself? Literally, he has no other objective other than to, make everybody's lives a living hell in court.
Yeah. He's gotta at least hire someone to do oral argument.
No, he definitely does not. I don't. I do not. I want him to do oral argument.
No. I mean, from his own perspective, I would love for him to just keep jumping up and going, I object.
Well, he's in the commercial district
in New York. If he's gonna go stand in front of a judge and represent himself, I will go to that. And I will report on it.
It's not just any judge. It's like Barry Ostriger in the New York commercial part, who apparently was some partner at some big-ass law firm and was famously like a humongous prick. I just can't imagine this guy flouncing around in front of him and getting any kind of traction, but we'll see.
Yep. He's just going to keep going. My lawyers wrote something about that, but I did not understand any of it. Just trust them. But it really is crazy to do this pro se. This is the one thing, the one bit of actual advice that Mike Dicta will give to all of our listeners out there. You've heard us talk. You don't have to be a genius to do this, but you kind of have to do this to do this.
There are barriers to entry.
We're not necessarily geniuses, but you sort of learn how to do the dumb specific thing that we do, and it's not the kind of thing you just want to walk into cold.
Well, but he had because
the other people know the
and
rules.
He had a good case, and I think
he had good attorneys,
and a great set of attorneys who completely slapped Simon and Schuster down the first time. And I have to say, I think this is going to be a case where you snatch defeat from the jaws of victory.
Ambrose Burnside. Classic Civil War general.
One is the loneliest number that you'll ever do.
All right, so I'd like to thank everyone who joined us today. Tarik, my mentions on Twitter. Michael, who is Fleeroff on Twitter. Mark, who is Kev, who is kept_simple. And I am Ugarls, Charles Starr. Thanks again for listening to Mike Dicta. Good night, everybody.
Thanks, y'all.
Thanks.
All right.
It's the saddest experience you'll ever know. Because one is the loneliest number that you'll ever do. One is the loneliest number that you'll ever know. It's just no good anymore since you went away. Now I spend my time just making rhymes of yesterday. his number, only 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 his number.